Hi, I'm Jason Sullivan of Rathbone Group, and this is On Subrogation, part 2 of our series on emergency response liability. In our first video, we discussed bystander liability. In this video, we're going to look at alarm companies. Going back to our fact pattern, your insured has a home that burns down. In this situation, prior to the loss, the insured had gone out and purchased an alarm safety system. It was a smart home. Everything was interconnected. The smoke detectors were set to automatically call 911 anytime that they went off. Unfortunately, your insured was out of town, and they get a call from their neighbor, and they say your house burnt down to the ground. And the insured is overwhelmed and upset. And then they think, well, wait, how did this happen? I purchased this super expensive security system, and this alarm company was supposed to take care of everything. They said they would. In what scenario could the alarm company be responsible for damages? An alarm company is going to have the same responsibilities to perform in a non-negligent manner. This means that employees need to set up the system correctly, make sure that it's calibrated. If there is a response, they need to notify the proper authorities timely. They need to give the right information to the authorities. If they do not do this in a reasonable manner, or if they're negligent, they may have responsibility. The contract, the services, or the purchase for the equipment may also have some contractual liability or warranties that the company gave your insured, or they implied that we will be able to get the police to your house in less than 1 minute. Things like that are now all going to create duties on the part of the alarm company, and if they don't meet them, they may have some responsibility. Alarm companies are aware of this, and there are 3 common contractual things that they use in order to avoid or limit their liability in these situations. The first thing that an alarm company may have in their contract is an exculpatory clause. This clause states that the alarm company will not be held liable for its negligence. It's a complete bar on any claim that may be asserted against it for damages caused by the company's negligence. Now you think, maybe that's not fair, and that's exactly how the law looks at it. Courts and judges are going to determine whether or not that exculpatory clause is unconscionable. Would any reasonable person agree to it, and would any honest and fair person expect that term to be agreed to? The court may also look at public policy. Is this something that we want to have companies allowed to do? So they'll use a balancing test. The court will look at the type of industry and type of company and service they provide. And is this something subject to regulation? And is it in the interest of the public to have this subject to regulation? And should we be regulating it? And what the company is doing is something we definitely don't want them to do because it's against the public good. The courts will look at either of these things, whether it's unconscionable or against public policy, and they may determine that that clause is not going to be enforceable. The other type of contractual provision that the alarm company may use is a liquidated damages clause. Liquidated damages will say, if we are negligent, our damages are limited to X. So damages may be set to $1,000 or some other number. Courts will again examine this and see if this is going to be an enforceable clause. Liquidated damages are generally frowned upon when we're looking at contract law. Damages are supposed to be compensatory, not punitive. So the court wants to make sure that the damages are compensating the party for the loss that actually happened, not more and not less. The question that the court will look to is, at the time of the contract, was it reasonable or foreseeable what kind of damage may occur? And is that damage subject to reasonable certainty? Can you determine what that is? In a house fire, if the alarm company does not notify the fire department, then certainly that foreseeable loss is that the home will burn down or sustain more damage because the fire department wasn't alerted and didn't get out there in time. In damages, that's pretty easy to calculate. What does it take to repair, rebuild the home to its pre-loss condition? So for a liquidated damages clause, it's a question of whether or not the court thinks is the specified amount reasonable, and can the damages be determined with any type of certainty. The third clause that the alarm company may use is a limitation of liability clause. In this case, it may read something like, in the event that there are damages, our damages are limited to the contract service rate, or to $1,000, whichever is less. Something like that now caps the damages, but it doesn't set them at an exact amount. So it's going to be actual damages or whatever the service level is or whatever fixed dollar amount that's going to be. Courts look at this in two different ways. In some states, the courts will look at that as though it is an exculpatory clause. They will say, wait, is this conscionable? Is this fair? Is this against public policy? And if they determine that it's not, then they're going to rule that that's not enforceable. But again, they use that exculpatory clause type of fairness, unconscionability test to determine whether or not it's something they're going to enforce. In other states, they may use a liquidated damages test. Is this reasonable? And are the amount of damages subject to some certainty? It's interesting because courts in different states use that liquidated damages test for the limited liability situation and come to different results. So in Ohio, there was an alarm company that put a $50 limit on their liability. That was the maximum that they could have. And the court found that that was not reasonable, and because home damages are subject to somewhat certain factors, like how much it costs to repair, that was not something that could be enforced. A California court looked at a very similar clause that limited damages to $50, and in that case, they, again, looked at the liquidated damages. Was this reasonable, and were the damages subject to certainty? And they found that the damages at the time of the contract weren't subject to certainty. In other words, when the parties made the agreement, it was really uncertain about how much damage there could be, and therefore the court held that that was an okay provision, and they upheld it under that liquidated damages rubric. So anytime that you have a claim where there's damage to your insured's home and response to that is of the essence, and it appears that maybe there was a failure with the alarm company or something like that to notify the authorities to come to the loss, then you have to think, is there potentially a claim against that alarm company? And the things you're going to want to look at are, number one, the contract. What does the contract say? And are there any limiting clauses that we've just discussed in that contract? And then look at the state law that you're in and see how it's going to approach those clauses and see whether or not they're likely to be upheld, which in that case is going to probably limit the damages the alarm company is going to owe, if anything, to a much lower amount than you're paying out on your subrogation claim. Or will the court throw those out and say, look, we're not going to enforce these for these reasons, and therefore now you can pursue the full damage that you're seeking for the increased loss due to the alarm company to notify authorities. For On Subrogation, I'm Jason Sullivan of Rathbone Group, and that's the long and short of it.